Great, let's go on the record in the matter of the City of Wyandotte versus Justin Miller, 26722, and then the matter of 24228.
Your Honor, good morning. Richard T. Serrano, P33828, on behalf of my client, presently in custody, and he is here for arraignment only. Please state your name, sir.
Justin David Miller.
Okay, and so there's a new charge. So let's go over the new charge first, counsel.
All right. And what was the case number on the probation issue, Your Honor?
The 24, 24228.
Thank you. As to the new charges, Your Honor, I've advised my client of the nature of the charges. He understands them. I've also advised him of all of his constitutional rights. He signed a form regarding that. I believe you understand these matters. Your Honor, today we wait for him reading, stand mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And we will schedule this matter for pretrial.
June 10th at 8.
June 10th at, you said 8:30?
8:45.
Sorry, 8:45 a.m. Okay, so then we have that bond we can address. Counsel, let's handle we also have the jail review. Since your client's in custody, he continues to blow the court off when he has a scheduled jail review. Now we can handle the jail review. Were you able to speak to your client regarding the jail review, counsel?
Yes, I've read documentation from the probation department. He acknowledges that he missed several tests as alleged. He's going to plead guilty to that charge, and we'll address the court afterwards.
Well, there's nothing to plead guilty to, counsel. On the jail review, this court had previously taken your client's, the court sentenced your client to
60-day jail suspended.
60 days jail suspended, to defendant to continue testing, clear up warrants, and comply with Third Circuit Court probation. And, well, let's just say this, that as of December 2nd, your client had failed to appear for the jail review. And that was back in October 21st of 24. And then he was finally arrested November of 25, had not provided proof of treatment. Your client stopped testing, and then still has warrants. So now, he's arrested on a new case in Wyandotte here.
All correct.
All right, and so as to the recommendation that your client serve the 60 days jail, counsel, what should I know?
Well, Your Honor, I'd like to know how many days credit he has, if any. So because he's acknowledging that he did do those things, he did say that he had a lot going on. So many other clients do say he does not have any other matters pending. So we leave it in the court's discretion, Your Honor. Naturally, we would like some type of alternative other than straight jail time, but I told my client, when you don't appear or abide by the court's orders, you more or less put yourself in jail. So that would leave it in the court's discretion.
All right, well, what type of alternative is it that you are seeking for your client, counsel?
Well, he mentioned something about like community service, things of that nature, since he's a plumber assistant now, Your Honor. He's single, supports no minor children, lives with his father. He's 31 years old, not on probation or parole. As I mentioned, nothing pending other than the warrants that he has to clear up, which he said if he gets out, he's going to address those. Other than that, Your Honor, we leave in the court's discretion. You can do community service or something of that nature.
Oh, that's not an alternative this court's thinking of. Absolutely not. Mr. Miller, did you complete your probation in Third Circuit Court?
Yes, I completed my felony probation. That's one thing I did get to do. That was just overwhelming. I'm sorry. I had about the miscommunication, but I did complete my felony probation.
What was the miscommunication, sir?
That you guys didn't hear from me. I forgot about the bond violation issue.
Sir, you didn't forget about us. You completely ghosted us. This
I probably
court,
got scared when I heard the 60 days or something. Sorry.
what?
I said I probably had got afraid. I remember about the 60 days or something. Sorry.
Gotten afraid of the 60 days?
I think that's what I was, or that was alleged, or that was the term, or if I kept messing up.
Sir, I'm sorry, but you're confusing me. Did you forget about us, or were you in fear of serving your 60 days? Which is it?
I had fear, and I had a lot going on just with my living situation.
Sir, having a lot going on is not a valid reason to blow off the court. Many people have a lot going on. I'm not sure if a lot going on was the continued drug charges that you were getting, or what, sir? If you test right now, what's in your system?
I believe nothing. I smoked marijuana. I smoked the marijuana probably a few weeks ago, so I don't know if that'll still be in my system. Other than that, nothing. I'm off all my other. I'm off all. I know no more probation. I completed them. I've been just trying to do right for the most part. Gotta straighten out my license.
Well, sir, it appears though, per the police report, that you made a statement that you had just gotten done smoking marijuana with somebody over an e-course when you were driving, which you're not allowed to drive anyway. And so apparently there would be marijuana in your system from last night. But here's what this court's going to do, sir. You've done zero as to what this court ordered. Zero. You stopped testing. I gave you an opportunity, sir, to stay out of jail. You declined that opportunity, and you continue to decline that opportunity because you continue to ghost us and not even appear. So therefore, this court's going to order that your client is going to serve the 60 days jail on the jail review. Let me see here.
Credit for time served, right?
Well, so counsel, let's see.
He was arrested.
March 5th of 24, he was in custody. And then it appears as though March 13th of 24, bond was posted. And then your client was released from custody, so that would be 8 days.
Thank you.
So and sir, let me just be very clear. I didn't even give you additional terms other than continue your testing and comply with your Third Circuit Court probation. I didn't give you probation terms to follow or anything of that nature. And you completely, sir, just blew everything off with this court.
Sorry, I think I was focused on my just kind of. It was hard to get off that other probation. I'm sorry.
All right, credit for 90 days on that matter. And then council, the court's going to order a $1,000 cash bond, but your client's in custody on the other matter. Not to possess or consume the alcohol or drugs and no driving, which, as you'll be in custody for the next short bit, should not be a problem to comply with. Okay, we'll see you back on June 10th. Thank you. Have a good day.
Personally, I think the judge handled this case exactly the way a judge is supposed to. Mr. Miller was given multiple chances to avoid jail, including having his 60-day sentence suspended as long as he kept testing, stayed compliant, and appeared for his reviews. Instead, he admitted that he stopped testing, ignored the court for more than a year, and only resurfaced after being arrested on a new case. I can understand that life gets overwhelming and people make mistakes, but being scared of going to jail is not an excuse to disappear and pretend the court doesn't exist. The judge was absolutely right when she said that many people have a lot going on in their lives and still manage to follow court orders. At the end of the day, this wasn't a harsh punishment. It was simply the consequence of repeatedly refusing to take advantage of opportunities that were already given to him. If anything, this case shows that judges are often willing to work with defendants. But once someone keeps ghosting the court and ignoring every condition, eventually accountability has to kick in.